Great. Hi, good afternoon, and welcome to this episode of The English Show, episode 39. My name is Stephanie here at Beltran, Brito, accompanied by my two partners. Gil, how are we doing today?
I'm doing great. How are you doing?
The most tropical attorney.
I am.
We're doing pretty wonderful.
Always.
Alexis, how are you doing?
I'm doing great. How about you, Stephanie?
We're doing fabulous. We're doing good. We've got, despite the fact that we had talked about all summer, that usually the summer is slow with immigration news, believe it or not, it's not. So last week we did have new information regarding the F1 visa. Also, what was the other change from last week?
From last week?
Yeah.
I don't know.
No. There was
We
two.
did the visa bulletin.
Visa bulletin, F1, and one more.
And there was something else.
There was something else.
Oh,
anyway.
man. Yeah.
We'll jump back to that. But today we also have some breaking news as well. So that there goes being a slow summer, right?
So
Exciting.
yeah, I mean, Federal Register announced this morning they are now changing the policy. Any asylum applicant may not be no longer afforded the opportunity to attend an interview. They may bypass the interview phase on certain cases, which I'm assuming they're going to have an internal criteria for.
Yeah.
And from there, depending, you may go straight to immigration court to decide your case. As opposed, this is a dramatic change, guys.
big
It's
change.
very significant.
It's very significant
Yeah.
change.
I mean, it gets a lot of people who, expect the process to maybe take 6 months, a year, for many people, much longer.
10 years.
right?
Yeah.
We have cases that are beyond 8 years at least, with the expectation of I have my right to have an interview with an officer
Mhm.
for an affirmative asylum application. Well, now they'll send it to EOIR without the interview and without a reason why.
Mhm.
You're no longer getting the document that affords you an explanation. And I mean, I think you have to be prepared. Be prepared.
What they had essentially stated in the notice is that the current system where they had first an interview with a USCIS officer, and then if it were to be denied and then sent to court, they were saying that it was essentially giving individuals 2 bites at the apple, 2 opportunities. And that's what they're trying to reduce. But what does that mean for you? For individuals who were in a situation where they were sort of doing an asylum, but they wanted to do petitions on the side, it was a way of buying time. This is no longer a mechanism to buy time. I wouldn't treat it as such. It was already very limited because, as we know, you aren't allowed to adjust status for the grand majority of cases. But if this is a situation where they're going to very quickly put you into court and put you into proceedings, this isn't really buying you the time that you think it is. So those individuals need to really consider whether or not they're filing asylum petitions and instead focus on potentially non-immigrant visas and immigrant visas.
Yeah. I mean, they abused the system for
Right.
years. A lot of
That is the
frivolous
truth.
asylums were filed. It's a well-known thing that probably the bulk of the people applying for asylum really don't have such a fear of persecution in their home country. And unfortunately, that's muddied things for people that actually do have that fear. I speak to people all the time that have legitimate fears to return to their country, which is, for example, I was talking to a journalist yesterday, and he's like, yo, there's no way I could go back because I did an article in a publication. They literally went and said they're going to have physical violence against me because what I wrote in the newspaper. And that's a 100% legitimate claim to an asylum. And I told him, obviously we're talking cases, stuff like that. And I said, listen, I actually think your asylum claim is probably very valid. And I would play it out. But I think it's what's going to stave off is people, like you indicated, Stephanie, just doing this to do something.
Right.
We have this idea, well, let me get a placeholder going so I could get a work permit and then go from there. Something interesting, are they going to be eligible for EADs? Because there's no asylum clock on that is, the asylum clock is going to start when they file 151 days, then they're eligible to file for an EAD.
Mm-hmm.
Are they still going to be able to file for an EAD? I don't know. I would imagine so.
I have another one for you. Do petitions of non-immigrant visas still have to continue paying the asylum program fee? If there's no real
Yes.
asylum,
I'm going to say that's a solid
right?
yes.
Like
Yeah. Anything money related, it's probably yes, they're going to make you pay.
Technically, that was to.
I love where you're going with that.
Right, but technically, that was to
Yeah,
pay
I love where you're going
for
with
the USCIS officers to do the asylum interviews.
Now they're going to
at the
say it's to
local
pay for,
office.
it's to pay for
The
the backlog
judges.
and the court
Yeah.
and the judges and whatever else they go ahead and invent. So
Which then I don't know the finances, but are the judges even paid by USCIS?
I don't think so.
No, those are now DOJ,
DHS,
right?
Sorry. Exactly.
Yes.
It's DOJ.
Yeah.
So they're
DOJ.
funded by DOJ.
Are they? I'm not sure 100%.
I have to. I don't know.
You're going to
that.
have to double check.
Yeah.
I don't know 100%.
It's like now that
Yeah.
money, okay, so are they going to
Yeah.
continue?
I always
getting the
understood
fee?
that they were separate from USCIS.
I thought
EOIR
so.
is
Yeah.
under DOJ.
Right. So then the USCIS asylum fee, where's it going?
Hey man, someone's making big bank. off of
Someone
it.
is making money. Okay, so anything else we want to cover there?
Immigration news?
Uh,
What
No,
else?
with the asylum.
Asylum? I mean, there's
Asylum,
nothing, I would just say be on top of your application. Understand that if you have a legitimate application, of course you should apply for asylum. If you're out really on the fringe and you're like, I'm just going to do this to see, let me hang out. It's like, no, there has to be other alternatives. You have to reach out to us. You have to have a consultation with an immigration attorney. You have to discuss options. I think the idea of just let me enter the U.S., file an asylum, and make an asylum claim that maybe I may not be eligible for, I think those days are probably over.
Absolutely.
I mean, the truth is, outside of the procedural process for an asylum, nothing is changing. It's the same. If you had a pending asylum and no other status, any I-130, I-140, unless immediate relative, there's a very few limited number of exceptions, you could not adjust with USCIS. You were going to give it a long shot with the immigration judge, or you had to do consular processing. So I think this process, what it makes it more apparent to people is I need to prepare to depart the United States or at some point leave for a consular interview. And what does that mean? You don't want to be subject to a 3 and 10-year bar, right? That's a big one. And there's a waiver under limited circumstances, but for most employment cases, there really isn't. So planning, having that consultation is of extreme importance. I think in all practical matters, nothing changes other than those who already have an asylum application.
yeah. The other one that was the one that slipped our mind was the other change was public charge.
Oh my God, I'm sorry.
Yes,
Yeah,
public
public
charge.
charge.
We talked about it last time.
So if
we
you guys
did.
have any if you guys have any questions regarding public charge, which is also sort of a big change announced by immigration, we discussed that on episode 38, so you can find it on our YouTube. And we also discussed the changes with the F1.
And just to reiterate, that's September 18th.
Correct.
All
And then
AOS filed
F1 is September 15th.
15th.
Yeah.
Yeah, it was
Yes.
like a 2-3 day difference.
I've been receiving a lot of F1 questions, many questions of F1. The schools are concurring that as long as you're filing a change, I'll just give you an example of this morning. Program ends in January. She's been on a language program for like 5 years now. They're like, yeah, that's not going to work anymore. The language program is going to be limited to 2. But she's now entering into a academic degree, like a bachelor's.
That's perfect.
And I said, she says, should I do the transfer, do everything now? I'm like, absolutely, do it now. Before September, she's doing everything, so she's not going to be required to file anything with USCIS. She confirmed with the school that was the proper, that is their understanding of the situation as well. So it's just good to have the backing of the school. But I say be very careful with that issue and make sure you discuss it with your DSO, with the school, get everything in writing, make sure that you're not obligated because of your program or because of when you're filing it, you're not obligated to file a case with USCIS. That was the big change, by the way, for extensions. You may also the grace periods, but more importantly, if you're in the US after September 15th and you're filing for an extension of a new program, as opposed to just filing an I-20, you will now have to also file something with USCIS, an extension. You will no longer be given duration of stay, and you will have a finite date when your program ends, which typically is going to be indicated on the I-20. Now, all those groups of people have F1 previously with valid I-20s are basically grandfathered in until November 2030. Okay, approximately. They give us 4 years there to complete a 4-year degree. So keep in mind, keep on top of it, and don't assume because your program end date has a different date or whatever, and that you might have an I-94 expiration and you're not aware of it. You need to verify everything with the school. Right now, they're all duration of stay. After September 15th, they will no longer be duration of stay.
I have one for you because it came up in a consultation today and I haven't had a chance to double check it. if the OPT is approved, let's say this week,
Yes.
so it will expire after the September date.
Yeah.
The grace period, we're understanding it as 30 days.
It's grandfathered in.
So it's the grace period we're understanding
60
is
days.
60 days.
60 days. I
Even
say
though-
grandfathered in.
Okay, so even though the OPT will expire after September, the OPT will assumedly expire.
When did you obtain the OPT?
It hasn't been obtained yet. It's been
Oh.
applied for.
I understand. Yeah.
So the OPT will probably expire. Let's say it gets approved August 2026. It'll
Mhm.
approve through August 2027.
I think cases filed after September 15th are the ones that are going to be affected. What I understood from my interpretation of the student visa site with I don't know who runs the student visa site.
It's I think it's Department of State.
No,
maybe?
No, it's DHS.
It's DHS,
Yeah,
right?
it's
Yeah,
DHS.
it's called like studyvisa.gov.
Study in
or
the States.
studyinthestates.gov.
DHS.
I was there reading everything. My interpretation of it is that you're okay with the OPT as long as whatever took to go ahead and apply for that happened before.
Before the date.
Okay, it happened before. So I let's play it by ear. I don't know.
Because I think that question is going to come up
Yeah,
for us,
it's a good
especially
question.
next year. It's going to be like, all right, when do we need to file? By day 30 or day 60?
I'm just going to tell you,
There'll be
go,
clarity with
go
that.
with 30 days.
Yeah, I would say go
like
with 30 days to be
in the
safe.
future, I'm going to force our clients to go 30 days regardless. You got an extra 30 days? Beautiful, wonderful. We need to file cases, change the status, extension, whatever it is. We must do it within that 30-day window after completion of your program or
Right.
completion of your OPT.
All righty.
I mean, I think the only other news that's out there is TPS is ending today for a few people.
For who?
Haitians and Syrians. And so there's like 500,000 Haitians.
Are
Oh,
you
the Haitians,
serious?
Yeah.
right.
Wow.
Haitian-
And
was
so
today.
Supreme Court ruled
Mhm.
that, sent it to the lower court. So they have officially lost TPS as of
No, that we
today.
knew. Right.
Or
right.
yesterday.
Which is the end date. was
27th.
today.
Did they have a
Yes.
grace period to depart the U.S. or we don't know?
I mean, really, I think it's just the general grace period. Get out of here as soon as you
Yeah.
can.
What's going to happen to those people? NTAs?
Listen, NTAs.
Yeah.
We saw it before, and
Yeah.
other countries are subject to lose it fairly soon. So for those who still have TPS, start planning the next step. TPS is not going to last forever, and it's really important that that you have that in mind.
If we jump back just one more time to the asylum thing, I
Mhm.
think if you have an asylum pending, now knowing this information that they could switch you to court at any time, I think it is worth speaking with an immigration attorney to potentially file an I-140 petition so that, God forbid, you are sent to court and it doesn't go negative, it doesn't go well for you. You already have an I-140 in the works, potentially for consular processing. So that is what people are beginning to consider. You guys know from watching our channel, perhaps more on the Spanish side, that typically we were averse to taking these cases, but now we're really opening up because we know that these individuals are going to need a plan B should
Absolutely.
they need to depart.
Well,
the
because
United
the
States.
reality is, before we're like, okay, I get the I-140 approved. I would always ask people, are you really going to travel outside the U.S.? Are you really going to do it? If you're really going to do it, I'll do the case. Beautiful. But if you're not, is it really worth for you to do it?
Right.
But now I don't think they're going to have an option. Like the
Because now
option
they're
is
before.
now they're going to be like, okay, you have an
They
order of
are gonna
removal
travel.
and you need to leave voluntarily, or okay, they denied your asylum. You have a
Yep.
voluntary departure, and what else is for you? You're going to get a tourist visa again?
No, listen, you're not.
It's just not
Really
going to
not.
happen. It's
You're
not going to happen. I think then they have to do the I-140. I mean, really, there's not.
The
And
good
it's
thing
also
is-
nice to already have it.
Oh,
I mean,
agreed.
the time it takes to
Yeah.
prepare, to
Right.
submit, you don't have to do premium at that point. Guess what? You don't want to be subject to the 3 and 10 year bar. The idea is to have that I-140 approval. There is really technically no limit on as to when that I-140 expires. There's a whole consular process. We could get into that in the future. If you guys want more information, let us know. We'll do a whole episode about it. But applying for an I-140 today makes sense, or preparing, because this is a benefit
I mean, you might be in front of
a
a
year from
judge,
now.
but look, remember. So even
Yeah.
I don't want people to think that I'm going to be in immigration court tomorrow,
No.
and I'm going to have an order of removal. No, you still have a legal process. They're just, but the
Sure.
process can be directly in front of the immigration judge.
Yep.
And let's be very honest, the likelihood of winning an asylum claim in front of an immigration judge compared to an immigration officer is probably drastic.
Mhm.
And you have a much less probability in front of the immigration judge. So knowing this, that will not be a fast process. Okay, it's a multi-year process to have a trial, first your initial hearing. By the time they schedule, so this is interesting. They have a massive appointment backlog, and now they're about to add hundreds
Way
of
more.
thousands of new appointments into court.
Yep.
I just
The
don't
reason
understand.
USCIS is doing this, one of the reasons, is to clear up their backlog. Well, EOIR probably has a larger
A
backlog.
monster.
Yeah,
they're
they're
going to
just
have a
going to spread it.
monster.
They're just going to send it.
They're going to
there.
have a monster backlog. So the reality is, you might have your first hearing in a year and a half. And then by the time you get into court, you could be 2 or 3 to a full-blown hearing on your asylum claim. You might be 3-4 years past.
And I don't want to get too much into what people make and earn, but I assume an asylum officer earns less than an immigration judge. Isn't it fiscally responsible to just hire more asylum officers than immigration judges?
You're speaking too much truth.
Yeah,
I don't know. I don't know.
man.
You're
It's
speaking
dude,
too much
it's-
truth.
Look, the longer we do this, the longer we understand how grossly inefficient the government are. I mean, every government, but ours,
Right, across the board.
everybody,
Yeah,
everybody.
yeah.
Don't you hear clients all the time complaining about their governments in their
Right.
home country or whatever? And you think, I'm like,
Mhm.
it's no different here.
Yeah,
It's not.
It's the same thing. It's just, yes, I understand. It's a different system and whatever. I get it. But, and they say, well, it works better. Well, it does work better. I agree fully.
Eventually.
And I believe in it. But
Sometimes, yeah.
don't think that everything here is like rosy and wonderful and makes sense. It just doesn't make sense. So let's go to the questions.
Well.
Wow, that was negative.
Well.
We're gonna try something on Alexis
What are we going to do?
today. I don't know if he knows.
What are we doing?
Okay, we'll see. We'll get to his question.
All
Oh,
right.
he's gonna have a countdown
About what?
What is this?
for
Uh-oh.
his questions,
I get a
Oh.
countdown.
for his answers.
Oh, I like that.
Oh, we get 10
I like
seconds.
that.
Well, no, not all of us, just some of us.
Okay.
You-
Get ready, guys. This is going to be speed responses today.
Oh wow,
we
amazing!
can do
All
that.
right,
I like it. I like the challenge.
of Nami Reza. Hi Tropies, EB2NIW approved. Wonderful news. I'm happy to hear that. Waiting for consular interview in Mexico. Can I visit the US with my tourist visa while I wait for the interview, or too risky? I am absolutely of the opinion that you are fine to travel to the US. Please do not stay here for 6 months at a time. Okay. Like, I have a trip. I'm going for 2 weeks and I'm coming back to Mexico. Can they ask you about it at the airport? Of course they can. Will they? Very unlikely. Why? Because you're going to be there 2 weeks. It's no big deal. The issue is if you, in your one of those trips, you were 4 or 5 months consecutively, this begs the question, why are you here for such a prolonged period of time? Are you working illegally in the US? Are you living in the United States? So those are questions that will transpire. I'm just telling you, if you stick to like a little bit of a plan, come couple weeks, 4 or 5 months later, you want to come for a week again. I don't have an issue with that. The problem is the length of time that you stay in the US.
Let me go with a question from Al Broer. Priority date is March of 2024, consular NIW. In your experience, are approval rates truly similar in regular versus premium, or does premium statistically receive more RFEs or noise? I know that every attorney has their own response here, so I would be great to hear from
Do we
Gil and
actually
Alexis
have
here.
is there actual
Data?
statistics on premium processing? There is not.
They haven't released
That there is no statistics on premium processing. So anything we talk about, we're only talking about in
to our
individual
personal
experience. Yeah.
Right.
Plus
So-
the boards and stuff like communicating with other attorneys across
Yeah,
the country.
yeah,
Right.
yeah.
But there's nothing released officially from immigration. So I would say in my personal experience, from an initial filing standpoint, I don't see a difference between regular and premium on initial filings. On upgrades, I do not see positive results when there has been, the NIW has been pending for a long time on upgrading to premium. If you're upgrading within the first 1, 2, 3, 4, even the first 6 months of the case is pending, I have no problem. And honestly, it's my same experience, whether or not we get an RFE or whether or not we get annoyed. But where I do draw the line is when the case has been pending for a very, very, very long time. That's when I do not encourage premium, because I do tend to see a decline in what is the result that I'm going to get. But what do you guys think?
I kind of agree. And I think it depends maybe too how long that case has been pending.
Yeah. What about from the inception? Inception, what is it? Do you feel it's the same?
I think it depends on the visa. I
Well,
think
in this case, NIW.
EB2 and NIW, I want to say it's probably relatively even. I'm still inclined not to do premium for EB2 and NIW.
I mean, so let's just talk about this generally. Across the board, are you more likely to get a case approved with regular processing or premium processing?
In general, across the board,
Yeah.
probably regular.
You think?
Yeah.
I think it's
It
very
fluctuates
I think
so
it
much.
depends on the category.
Yeah.
Yeah, and
Well,
and
EB2 and IW
the
alone.
cycle we're in.
Mhm.
I'll tell you, I'm not in favor of premium for EB2 and IW. I'm not in favor of premium for EB1.
Not right now.
And that's the reality. You know, my bread and butter for a long time is EB1s
Yeah.
and EB2 and IWs and O1s and everything. O1, I'll crank out premium all day long. You know
And
why?
I think it's almost necessary at this
Because
point.
they've made the system so unfair to wait 1 calendar year to have a response on an O1. Unfortunately, I kind of make clients do premium.
With a
Mhm.
job offer
and
that's set to start in
how
a
does
couple
that even,
months.
like, how can you even manage your
Yeah.
life when that's happening? So in that regard, I'm fine with it. H's definitely. So that's where I bifurcate. I bifurcate non-immigrant visas versus immigrant visas.
Yeah.
Non-immigrant visas, 100% go premium
Mhm.
most of the time. Most of the time, not 100%, 99%. Immigrant visa, I think it's on a case-by-case basis, and I think we need to really take a look at what's happening with other results before. And I always tell clients, okay, listen, we just received 4 or 5 premium approvals. Guess what? I've also received 4 or 5 premium denials. It's pretty
Mhm.
much split down the middle, which guess what? That's exactly what regular processing is doing
Right.
for us too.
Exactly.
Okay. So it just depends. So this begs the question. Are you going to receive very likely the same results filing premium, and you have at least the incentive of having a decision now sooner and making other options, you know, like available to yourself, like an EB3 or something like that in the future, versus letting it go and waiting the time? That's a very personal question, by the way. I don't know that there's a right answer to that.
I think there it's just a matter of strategy. I'm on an F1. I've been on the F1 already for 2 years. Can I do English any longer? I don't want to do a bachelor's. I already have a bachelor's, something that they're going to consider, by the way, now. Maybe you have to do.
I'm sorry, they're going to consider that for an F1. Somebody that's jumping into an F1 program. They have the equivalency of a bachelor's degree in their home country, and they're applying for a 4-year university degree here. And USCIS is going to determine if they're eligible to obtain an F1.
I think that's part of the consideration. If you already have a bachelor's, maybe it's a U.S. bachelor's.
Mm.
Not if you already have a U.S. bachelor's, at least jumping into the same program. I think you have to.
That's ridiculous.
Jump up. Not
that's ridiculous.
Not literal, not a lateral, but
vertical.
Vertical. Yeah.
Yeah.
Did you see something?
Can you jump? Can you jump vertical?
I'm gonna look it up.
Last time you jumped vertical, I heard that it didn't go too well, right?
Well, I mean, I just know that I jumped up and I also jumped back down.
So you jumped up, then you looked around, and your spirit was just like laying there.
Spirit kept going up. I kept going up. Someone pushed the spirit back down.
Okay, we'll keep. Stephanie's gonna look into that. Yeah. Alexis, grab the question. Go for it.
Here we go. So we're going with Alejandro Osorio. I filed the TN. USCIS requested biometrics before deciding. Okay, my I-94 expires in 2028, but I've already ended employment with my previous employer, meaning you already lost status. Does USCIS count this waiting period as unlawful presence? So as soon as you filed that application, you have legal presence, right? And so what you lost the moment you stopped going to work or the employment relationship ended is you lost legal status. So you're fine. Everything is now hinged on this application. You can't do anything else. Hopefully this extension, or I guess you're doing a change of employer, is approved. If it was an extension, I mean, what is the employer taking you back on? How's that going to work out?
How about you back up a little bit? Why do they have a biometrics appointment for a TN visa?
I'm assuming they did something here, an extension in the US, which you could do.
But it's very, very odd for a TN visa to receive a biometrics. I would say, I mean, do you have any type of like DUI, anything situation like that?
What's triggering the biometrics?
What's triggering the biometrics? That's concerning. Yes, it expires in 2028 before deciding my 94 expired 20.
I guess I didn't get a decision.
But I've already ended employment with my previous employer. Does USCIS count this waiting period as unlawful presence? As long as your petition's pending and you still have obviously a bona fide offer with the new employer and they filed everything timely, you needed to file that change of employer within 60 days of ending your employment relationship with your previous employer. As long as you did that, there should be no issue. You could go ahead and remain in the U.S. You are not accruing a lawful presence. If they deny the I-129, you will start accruing a lawful presence because you're no longer with your employer.
It's going to be exciting.
It looks like it's if you have a U.S. bachelor's.
Yeah, I wasn't too sure.
That makes sense.
So
you already got a 4-year degree. They're like, hey, go to master's. I already have a master's in the U.S. Okay, go to a PhD.
Yeah.
Okay, I already got a PhD in the U.S. What comes after?
Joder, tío.
What?
PhD?
What's
JD?
I mean, why can't I get 2 PhDs?
MBA?
LMNOP. Like,
Yeah,
I really
no,
can't
but I'm
tell you.
saying, why can't I get 2 PhDs?
I mean, a PhD to begin with, you could extend for like 5 or 6 years.
Yeah.
We had a client once. This guy was on an F1 for about 12 years, and we got him an I-140. He ended up the researcher at that point, right? And he was in the PhD program, and he just wouldn't do the final thesis presentation. They kept extending it.
Wow.
And he got
What
an
a-
extra year and
What
a
a
half.
gambit. Wow.
Yeah.
Incredible that they allowed that.
That's not going to fly anymore.
It's not going to go anywhere.
Well, that makes sense. That makes sense. But I think if it didn't make sense that if I have the equivalency of a bachelor's
Can't
in
get
my
another
home
one,
country,
yeah.
that I'm not able to get a U.S.
I think they're going to give you like that first one, that freebie.
Mhm.
But once you have a bachelor's equivalent here,
freebie that they overcharge you at a very expensive university to be a student visa holder. Freebie. It's crazy. Okay, let's go to I already answered Al Broer, but Al Broer, I'll hit you up again. March 24, Counselor IW. I'm 54-year-old father. My goal is for my teenage son to complete at least 1 year of U.S. high school. Would you keep waiting? How old's your son? I don't know, 13 or 17. I think it's a valid question. I would probably keep waiting since you're outside the U.S. That's my advice. Why don't you look into obtaining an O1 visa potentially, so he could do his high school here on his O3 while you guys are awaiting that decision. A great majority of my EB2 and IW clients qualify for O1A. That's kind of a natural progression of things. We could have that discussion. Al Broer, Alexis would love to talk with you about it.
we could do it. Hey, sometimes there's other options. Maybe there's an E2. Maybe they're an entrepreneur. Maybe the company they work for wants to open up shop here. There's an L. You got to consider things.
Damn.
Fernandito says, can I just crawl under a rock and wait this administration out?
A lot of people are
Let me
doing
know where
that.
the rock is.
A lot of people are doing that.
I'll join you.
But you know what I say, Fernandito, with that one?
Why
I say, listen, I'm going to explain something to you guys. Never assume what's coming in the future is going to be better than this.
I know.
Like, it's like,
Really,
I can't assume. I got to work with what I have. You understand? So it's like, this is the situation we find ourselves in. So yeah, it's aggressive. It's difficult. It's not easy. But we're still seeing results. It's happening. You know, it's like, I've just never lost faith, like, in our system, in the sense that, yes, sometimes it looks a little bit like it's rigged against immigrants, truthfully. But you know, to counteract that, I would say, how do I explain all the cases I've gotten approved? How do I explain all the green cards? I got my clients yesterday sent me their photo in their naturalization ceremony. You know, and these are people that I've known for like 12, 13 years, and they're U.S. citizens now. So how do you, you know, it's like, it's always been kind of tough, and it's always been kind of easy. It just depends what you're applying for. And I think really it's the ability to find that happy medium where we're able to successfully obtain a legal status for a client that allows them, not a perfect status, but it's going to allow them to work, to live, to study in the U.S. And from there, you're going to go ahead and jump into a green card process. So yeah, I would tell you, Fernando, I understand completely, but I'm still aggressively filing cases. And you know what? It's like, I still think it's better to go for it on most cases. Okay, not all of them. There's some that I mean, we're just going to pass on. But I think it's being much more conservative at the beginning of a case and being realistically, is this a real thing that I am eligible for? Talk to somebody today, guys, this morning. I thought me and him were going to be talking about an EB1. Nah, he already filed an EB1. I'm like, okay, he's on an F1 now. And I'm like, okay, beautiful case for an EB1, by the way.
O1.
And of course, obviously I said O1. And then I said, he's like, yeah, I'm actually thinking about the EB2 and IW as well. And I was like, okay. I was like, in my head, I'm like, okay, maybe, you know, we already did an EB1. We're going to, you know, we don't even have the result of the EB1 yet. It's normal processing. And he goes, no, I already filed the EB2 and IW.
Oh my gosh.
Or I'm about to file it with another
nuts.
law firm. I'm like, okay. He told me his proposed endeavor, which, by the way, I loved it.
Okay.
I thought it was right on. I thought it was spot on. I even told him I usually would be against you doing an EB2 and IW because your type of career, but it's such a good proposed endeavor that, and what but they were not doing it properly. And I told them, you need to start taking steps to make this a reality.
Sure.
He's creating a foundation. He's
Yep.
doing all this stuff. I said, get all of that going, and you could provide it in your EB2 and IW. And I tried to give him that advice. Obviously, I said the 01. But my point is, it's so funny. Fernandito's like, hey, I'm going to jump under a rock. Then you got this dude who's in legal status. He's on an F1. I said, let's jump into an 01. He says, you know what? Let's just go for the green card, Gil. I'm just going to go green card for now. And by the way, you know what I'm doing? Perm.
I had a feeling, I'm like, tell me there's a
Perm's
perm
gonna be the
involved.
winner.
That's all
I
that's left.
told him, I
Perm's
said,
gonna be the
listen,
winner.
we'll probably
Believe it
win
or
the
not.
perm. And I said, if you get an RFE on that EB1, I'll crush it for you. But he has a great career. But I'm just saying, like,
Someone's throwing the kitchen sink.
Yeah. So you have, I
Plus,
would
they
say,
qualify.
we
Do the whole thing.
and he qualified, and you have the spectrum. You have people who are just like, oh, I give up, and the other people's like, I'm gonna go for
Full send.
everything, full send. Anyways.
What I was going to say is basically what Gil has said is that you don't need to necessarily just crawl under a rock. What you need to consider potentially are exploring non-immigrant visas for longer than you typically would have in the past. That's typically my response in a situation where, we're fighting a bit of against the system. Let's wait this out in a way by going for a non-immigrant visa. That's what I would say there. Let me take another one from Instagram. Gerald Nino, after an EB1B denied on final merits analysis only. So frustrating. Premium processing. Is refiling a good idea? Also premium. We are O1A, O3 holders. Okay. So I recently had an EB1 denied on final merits after giving him 8 categories. When I tell you the frustration is real, the frustration is just unbelievable. I would not refile right away. I think that is it's a negative sign, especially currently with the current administration and with tendencies. I don't think that's the right move. I would give it at least maybe 6 to 8 months so that you can go ahead and show on the form, you can indicate, hey, listen, I received a denial. This was the commentary from the officer, and this is how I have addressed it. These are the things that I have done recently. I want you to be able to present something else and address that officer, especially if you are O1A and O3. The other idea I would say is potentially explore, if you're an O1A and your petitioner is open to it, potentially explore a perm, and then later on you can refile an EB1 as well. But I wouldn't do it immediately. I would wait.
That would have been a good opportunity for the clock.
Yeah.
It wasn't that long.
We should have.
You hijacked my question.
I just picked this random
First
question
of all,
from
it wasn't that
Kami.
long, and your response to my Fernandito question was even longer.
I was gonna call a clock on me too. To be honest with you.
I was looking for the clock here, but I couldn't find the button.
Okay.
Camille, I am a Spanish J1 French sponsored.
Interesting.
Okay. I applied for a waiver and DOS responded by email stating that the 2-year home residence requirement does not apply to me. Do I need to wait for an official document? I mean,
that's an advisory opinion, Alexis, and
Yeah.
I do them all the time. And we just
you
received
just run with it.
I just literally received one this morning. That for me
Is
is
enough.
the Department of State
Yeah.
saying
100%.
you're good.
Yeah.
Okay. You're solid. You don't need any separate document. Keep that email, obviously print it out, keep it in your file just in case.
I have a question, Cami, if you could respond to us, because I'm currently waiting on that same thing, Department of State advisory
How long
opinion.
did it take?
And I'm currently on week 8, even though they
no.
told me that it's 6 to 8 weeks.
I was going to say mine was 6.
They
Yeah,
told me
6.
expect 6 to 8 weeks, but I'm already on week 8. So Cami, tell us how long it took for you.
Tell us, Camille.
It's good.
You got yours at 6 weeks?
6. I want to say it's 4 weeks.
Man.
I want to say it's
why
4
is
weeks,
mine
but
at 8
I think
weeks?
I think we're under 6. I think it actually surprised me how quickly they responded. Okay, Marissa, I see you skipping this question. So whenever you guys are skipping questions, that means
I didn't skip any
you
questions.
guys. Stephanie skipped it.
I tried to help
is that
Instagram.
is that Italian?
It is Italian. Marissa's
Italian.
Italian.
Entered ESTA in October 2022. Overstayed by 825. What's 825 days? It's nothing.
What
a
is it?
smidge.
3 years?
It's a smidge. 825 days. Who cares? Left 425. My husband's I-140 was approved. Excellent. If he gets his green card first and then petitions as following to join, what can I do a 601 waiver? What's the basis of the 601 waiver? That's my question. What would be the basis? Is there a United States citizen child? Is there your spouse is an LPR? Doing it based on the fact that he's
They're
an
doing it based
LPR?
Well,
Yeah.
I think it's follow to joints would be based on the I-140.
Oh, no, but the 601
So it wouldn't qualify unless it's.
I'm
an
sorry.
I-130
He's going to
petition.
have to I-130 petition her to
Exactly.
do the
Yeah.
to do the 601.
Yeah,
Excellent point.
That's my.
Yeah.
That was my
You
concern.
may, Marissa, need to have him. You could try the following to join. I'd probably have him file an I-130 for you as well.
Mhm.
Can you do a preliminary 601 waiver simultaneously without being asked by the consular officer? I think you can, but it's not necessarily advisable. Look, I'll just give you my 2 cents. Without that waiver approved, you're probably not getting a green card.
Yeah.
Like,
I mean,
it's
get the
just-
waiver, try with the follow to join.
Yeah.
I-130 is there, just in case, but do the waiver.
I think
Gotta do the waiver.
can you do a waiver on a following to join I-140? That's where I'm stuck. I've never done that. I've done I-130 601 waiver. I've never done I-140 601 waiver.
Yeah.
That's what.
And by the way, it
there's a
is fine
difference.
because earlier you said the USC, it's fine that it's an LPR spouse.
Oh, it is fine. It's an LPR. No. Right. But not, no, my point was
If
the
it's based
fact
on
that
the
it was,
I-140.
no, it was based on the I-140. So I said, okay, who's affected by this?
Correct.
I
You know?
forget the I-601 versus I-601A, so I'd have to go back and brush up on that. We don't do too many.
We
of
don't
them.
do a huge
Yeah.
amount of waivers. I
It's
get
been a while
involved
since
with them
I did it.
because they're kind of ancillary things we handle just as already part of a case that I'm handling and the person needs a waiver. I'll go ahead and handle the waiver. If it's a complicated waiver, I generally farm that out to somebody else that's a specialist on waivers. I would talk to a specialist in your case, to be honest with you. Okay.
It looks like I-601A. And then you could indicate the immigrant visa case
I-140.
on an approved immigrant visa petition.
Yeah.
Regardless of the fact that it's an I-130 or an I-140.
Yeah, it says
So it's
form
possible.
I-130, form
There's your
I-140,
answer,
or form
Marissa.
I-360.
That's your answer. You could proceed with
But
the following to join, but do the I-601A.
I-601A or I-601?
I-601A.
Okay, that's
A,
what I want.
yeah.
Clarity.
USCIS receipt number for your approved immigrant visa petition, whether it be I-130, I-140, or I-360.
And it'll overcome the inadmissibility.
If the following
of
to once the
tenure.
is it the following to join the petition? What's the petition number? The I-824. Is it the I-824 petition number?
She might have to do it during his NVC I-140 process,
That's complicated.
as in not during the follow to join. As
Right.
in try and be included with his NVC I-140 and do an I-601A. You understand what I'm saying?
And
Like
I'm
doing
assuming
it
your
now.
husband's outside the U.S.
Right,
so,
right, right.
Yeah,
Assuming it's not an adjustment of status.
Yeah.
Yeah,
Basically,
there
your
would be no reason
spouse-
for a follow to join unless it was adjustment of status. So.
of course.
So your, I would say maybe have your spouse.
I'm
do
sorry,
consular
excuse me.
processing.
Following to join means he already has a green card or he did an adjustment of status in the U.S.
Yeah.
So in this case, so if he gets his green card first and then petitions his follow to join, if you can avoid it, have your spouse do consular processing immediately since the beginning, not do adjustment of status, include on it and do I-601A waiver.
Okay.
That's
so
the best opportunity for you to
Okay,
include
just
it.
summary again. Do your EB1 approved NVC for your spouse.
Mhm.
Try to get into that
Mhm.
process.
Get it on the fee bill.
Get it on the fee bill. Start the 601-8 waiver parallel to that. I'll just tell you, those take a while, Steph.
Mhm.
Like those take 24, 27 months. Okay. And I-601A. You know, either one of you is going to have to be waiting.
But consular post in Italy, when you show up at the interview and you say you have a receipt notice for an
We'll keep it.
I-601A,
We'll keep it in
they'll
abeyance. They'll keep it in
Exactly.
abeyance. Hey, oh my,
Mhm.
is that that's like prime time legal advice you just gave her?
Honestly?
Mhm.
That's prime time. Like that's
Wow.
great legal advice. Me and Alexa were like, just marry an American. That's prime time. That was good. I like that. Oh, I'm sorry. That was my
Should
question.
have put the clock.
Yeah.
That was yours.
I keep looking for the clock. I can't find it.
Should have put the clock on him. Who is it?
It's you.
It's
because
me.
That was my
Yeah,
question.
you took over.
Oh, I apologize.
That's fine.
Let me see. Wait, because they're asking us something.
Do you have a super chat there?
Wait, you took off the one.
Hey, check it out.
You
Okay.
took one off.
It was Marissa's.
We'll move on with our lives. CJ Gomez, have you received DAD CO9 for Venezuelans? Absolutely. How long is taking AOS EB2NIW for Venezuelans? You know what? Since they lifted the pause, I've been seeing the EADs for Venezuelans be approved. C9 adjustment of status, like
Everything.
Cubans too, by the way.
Mhm.
I've actually seen it for
Everything.
Cubans as well. So very good news. How soon? I would expect in the next couple, probably 60 days. Hopefully, you should receive your EAD.
Alexis, we have a Q&A adjustment question that I feel like you should field. I'm going to put it up for you.
Here we go. Isabella
Cuba.
Gonzalez. I'm not Cuban.
I'm going to
but-
tell you, that's some racist, like, BS.
We
you're
talked
talking
about this the
right
other
now.
day. You're actually more Cuban than I am, which is
I am.
amazing.
You're from
I'm
Kendall.
born and raised in Miami. I'm from
You're from
Kendall.
Kendall.
I'm pretty Cuban. If
Doesn't
I'm
get. I'm not. I wasn't even born here. Like,
Oh, yeah. Well, let's see. Entered on ESTA in 2022, and I've been out of status for 2 years. My wife has a pending Cuban adjustment-based I-45. Could I apply for an O1 through consular processing? Would advanced parole affect my reentry? Wait, this is your wife? Why don't you just do the Cuban adjustment I-45 too? As well. So, confused here.
I mean, that's exactly the answer, but
yeah,
I didn't think
right?
you were going to say it like that.
I thought there was something else that I was missing here. Listen, you unless you do not want to be a legal permanent resident, you should file that I-45. You've already been here for more than a year and a day. You're married to someone who has the right to Cuban adjustment as a spouse of someone who is under Cuban adjustment. You can do so too. File that I-45 today.
how about if they left already?
Okay. This says I've been out of status, but if you were out of status and decided to leave, you would be subject to the 10-year bar at this point. So you would not be doing O1. And would advanced parole affect my reentry? I wonder what advanced parole you have.
I'm assuming you're going to apply for an advanced parole pursuant to an I-45 application. If
Mhm.
that is true, please do not travel.
Yeah.
In your
don't
case,
travel at all.
do not travel outside the U.S. It can be affected, and they may deny your entry. That's always been a thing. Now more than ever.
Two things. If you departed, you're going to have to figure out a brand new strategy. It's going to be marriage based. Forget about Cuban adjustment.
Mhm.
If you're in the United States, file that I-45. If it's already pending, you're just going to sit and wait.
Yeah, the O1 should not be consideration.
So
for you.
ESTA entrance, regardless. So this is what happened. He's married to a Cuban. Let's just assume, I don't know. I've done this many times. Cubans that also are Spanish dual nationals.
Sure.
They enter on the ESTA into the U.S.
Mhm.
They fall out of status as long as they've been here 1 year, 1 day. We found a Cuban adjustment. It doesn't matter that you were ESTA previously. You're still eligible to file Cuban adjustment.
Yep.
Cuban Adjustment Act is a completely different set of law than adjustment than normal adjustment status. Different rules apply. Okay.
That's it.
Great.
That was 10 seconds.
That was great. Let's
Sure.
do is this wow, you guys are really
Let me tee you up
skipping
from
questions.
Instagram. That first one, it's been asked several times
Okay, go.
on this one.
I'm under asylum. I got my EB2 and IW approved. I know AOS will be denied. And I heard coming to my origin country is the way to go. I can't apply in a third country. Is that correct? Okay, you know what? I was kind of researching this a little bit. What do you think here, guys? I actually have a fear to return to my home country, and it's legitimate because they're going to kill me if I go back.
Sure.
I need to consular process through NVC and consular process my approved EB2 and IW.
I know.
Can I request? I know it's a special request. Should I request a change of venue because of my fear of persecution of returning to my home country?
We get this sometimes.
I would imagine that the Department of State is amenable to that. And I'm pretty sure they are. If you could actually show things like, hey, I was actually had persecution. I applied for asylum or all this situation. Now, I feel we should be able to change the venue. Another way that I could definitely change the venue is if somehow are able to obtain residence in that country. That could be a strategy.
Even temporarily.
Yeah, even temporary residence, then I should be able to easily change to that consulate for you. So I would probably do that. Where would it be? I don't know. What country?
I mean, also,
Tell me the
let's
country.
say you're in Venezuela. Guess what? You get to go to Bogota.
You have to go to Bogota.
Right? So,
Yeah.
So you could just go to Colombia
yeah.
and not go to Venezuela.
How about if he's Colombian?
sure. That's
Where is he going to
possible.
go? Venezuela?
Yeah, I guess
No.
not.
Like that's the question. Like, where are you from? Okay. Sorry, Dan. Dan Candro.
By the way, Alexis found something important. The 601A, you had to have applied before you departed the U.S.
I understand. So it has to be a straight up 601.
So it has to be a
There you go.
And I think the 601 won't
Marissa,
allow
601, no 601A.
Sorry, okay, it's me. Let's see. King, he's excited to start his EB1 with Andrea. King is a king of the kitchen. Yeah, you have to do the clap noises. No! Oh my God. All right, let's
That's
see.
messed up.
Felipe, I'm applying for EB-290W. My I-140 receipt date was February 12th, 2025. My case has been pending for 520 days, but who's counting? And I have only received one update status regarding USCIS is currently processing the case. Normal. I think current official processing time is 27 months.
Yep.
So March, you're not even close to that.
Try June 2027.
Yeah, you're not even close. Mind you, the other day on the channel, we did have someone who said they got an approval after 3 years and what was it, like 2 months with no RFE. Okay, so keep waiting. There's nothing to be said. There's something that we can say. The USCIS system does not update to give you updates until they are actually adjudicating the case. So even though the case can be pending for 27 months, you're not going to get an update every 3 months saying, yeah, we still have your case. We're still going to look at it. No, it's going to say the exact same thing until they actually adjudicate it. So don't expect updates on the website until they're actually looking at the case.
True. Right.
Definitely not.
Wait.
Where do you put that one?
Whoop. Oh, you deleted it as soon as I clicked. There we go. Honoric, I'm Venezuelan at this very moment. My EB-290W was denied. I'm sorry to hear that. What should I do? I want to schedule an appointment with you. Thank you. I guess you know what to do. Contact us. Let's talk about it. What's your immigration status? What's your history? I mean, were you on TPS? Did you have an asylum? B2, F1? Let's talk all of that. Listen, the EB-290W pending never gave you status or legal presence. So what's going on there? If you're abroad, maybe as we discussed today, O1A, L1, H1B, those are options. Contact us. Where is it? Where is it?
It's going to come up soon.
We're out to lunch.
Yeah.
Hi.
Go to Beltran Brito, write to info. He'll respond.
I am not taking asylum cases. Jasper. Wait, don't tell me Beltran Brito is taking asylum. No, I'm not taking asylum cases. Asylums are affirmative asylums or defensive asylums filed either, initially with USCIS or before an immigration judge. I still will not do those types of cases. I used to do those cases a very long time ago, and I have zero desire to do those cases again. I've always liked winning.
Yeah.
And I feel that the attorneys that practice that, they have to be like okay to accept losing most of the time. I'll be honest with you. Just imagine you're a doctor that loses most of the time in your surgical procedures. So that's how I consider myself. Like, I'm not interested in that. Like, it takes a special type of attorney for that. And bravo to you if you're able to do it. It's just not me. It's not what I'm trying to do.
It's a different climate too. What was going on 10, 15 years ago is just so different from today. And I think there has been some abuse, and that's affecting everyone too, even the legitimate applications. It's tough. Hey, but thanks for watching us, Jasper. We appreciate it.
Go with Melly as well.
Hey, Melly, O1B case with Gil, Venezuelan start university in August, F1, third master's. I'll try to get first stage DCBT, then do premium processing. How is it taking with and without premium processing? For the F1, and I'll try to get first ACT.
I think the F1's already approved.
It shall start. Okay. O1B, if we're doing O1B premium processing, we're taking 15 business days to have a response, and we're seeing very good results. We're seeing F1s within about 30 business days to premium processing, and again, very good results. I would say without premium, F1s are probably in the neighborhood of the 5-month mark. Could be pushed out a little bit further. O1s without premium are a solid year, which is bad. It's very bad.
It's not good.
It's a headache. Used to have a processing time of maximum 8 weeks.
Yeah, that was amazing.
Used to be processing.
Such
I'm
good
talking
time.
for over a decade. Maximum processing time. 8 weeks, and then 3-4 months, and then 6, and then now we're in this year. So let's see.
All right, I'm going to go with Instagram, Clarissa. I currently have a pending EB1 petition and would like to know if I can file an EB-290W in parallel through premium processing. Clarissa, yes, you're never, just because you have a current petition in front of immigration, an I-140 in one category, it does not stop you from presenting in a different category or in the same category with premium processing. You can go ahead and file that.
Oh, yeah. Whoa.
I wasn't going to get the clock.
Oh, here we go. Did you know that today is Peru's Independence Day?
Oh, nice.
And Stephanie and Alexis, we showed up ready to represent. Well, happy Independence Day to you in Peru. That was less than 10 seconds. I love Emma. Emma, who also follows us. Fernandito, do not stress about it. That's why you need someone like Brito in your corner. Oh, man.
And Stephanie and Alexa.
Not Stephanie.
Emma,
Marcel.
what's the deal?
Listen,
I read
I'm gonna
this and I
explain
think
something.
Rocky Balboa.
Emma, what is the deal? You think Gil's going to towel the sweat off your forehead?
You'd be surprised what I'm willing to do to
This
get
guy's
a
gonna
case approved.
staple you back up.
LinkedIn, Angie. Thank you, Angie. Hello to the best lawyers. Thank you, Angie. We have a little. Oh, Albrar. What are we doing, Albrar? We keep doing the consular NW. Would you wait? No, we already took care of this, right? We got them. Well, again.
No.
Again?
You didn't. Yeah. This was done.
Build
just
an
now.
ONA. Oh, I'm sorry. It's a different one. Okay.
Yeah.
File a parallel NIW premium processing. No, don't do that. That one is a no-no. Build an ONA through your own company with minimal reliance on sponsors or third parties. Absolutely. That case, we can make it work. Your kid, 17, wonderful. In October, listen, you're not going to be here in October. Okay. I could tell you, I'm just looking at the calendar. We could try for a January start date. Okay. Like that's reasonable. You'd have to have October's not impossible for me. All right, go ahead and reach out to me and tell me the information. If you can, put a link to your like evidence package of the EB2NIW. That's I don't need the whole letter and everything, but just like the package of evidence. That's going to help me dramatically to know where you're at on a potential O1. Most O1s I want to have at least 2 to 3 months to prepare and file. I am able to file cases very quickly if the evidence is by and large prepared. We can file fast for you. I have August, September. Yeah, why not? I could do it.
Maybe sometime in
I
October.
can make it work potentially.
Yeah, for sure.
Also, what's the big concern there with the son being 17 in October? I know. I think
He wants to go to high school. He wants to go like probably senior. Probably wants to do senior year here.
The whole year.
Yeah.
That's right.
Please
You
don't
mentioned
send
it.
him as a tourist to do senior year.
Yeah.
While we get this resolved.
Great thing with the 03 though.
Somebody will tell you that.
Can study and then even go on to college.
What do you think of the idea if he has tourist visa entering as tourist and we change from 01 to 03 inside the US?
Sure.
What do you think about that after 90 days?
Changing the sun from 01 to 03?
No. They're entering the
Both.
US as tourists and I'm switching him to an 01 and the son to an 03.
Yeah.
And what's the question?
Should I advise that knowing the time frame?
I think maybe consular is a better approach.
Yeah. I mean,
if there are any
they may not have tourist visas anyways.
Yeah.
But what's my
Hiccups.
concern? I don't understand.
He wants the kid to start school already.
No, but 90 days. They'd have to enter
I would not file it
August.
within
I
less
think it's
than
going to take even
I
longer.
wouldn't file it in less than 90 days. I would.
No, I would not file it in less than 90 days.
Exactly.
Either.
I think you have a better likelihood of
processing
doing a
premium.
consular within 90 days and
Oh,
waiting the
that I
90
could
days.
do.
Yeah.
No, that I could do. That's what I was thinking about.
Yeah.
But anyways, just giving you that little bit of devil's advocate.
The fact is that we think about it. That's what matters.
Marissa has a follow-up super chat. Could I apply for Consular 01 and do INA 212D3? Look, a waiver of the 3 and 10-year bar, I've tried. I'm going to be completely honest with you. The majority of the times they have been denied, especially in your situation that you have 2.5 years of overstay after having entered on an ESTA. It is just such a high rate of denial. If you want to do it, I'll do it with you. I have clients who tell me, you know what, Stephanie, I have the financial means. I want to go ahead and give it a try. And I've done it. And unfortunately, actually, it's funny now. There's one client that I think of in particular that he was subject to a 5-year ban because he was found working illegally. We applied 4 years ago because he said, I have money and I want to try. We tried for the waiver of the 5-year bar. They said no. It's about 4 years later now, believe it or not. And now I'm doing my 01 and I'm getting it issued at the consulate and I'm fine because he waited out his 5 years. You are subject to a 10-year bar.
Steph,
The likelihood is just
212D3 that is only allowed if the consular officer affords you the opportunity. And unfortunately, Marissa, you need to apply for the visa first to see if that opportunity is going to be afforded to you.
Maybe I'm not explaining it correctly.
Yeah.
So basically, the reason I say if you have the money and you want to try for it, because I first need to send the petition to USCIS. USCIS needs to approve the petition. Then I need to set the consular appointment. Then when you're in front of the consular officer, you can get authorization from the consular officer to waive and to present a waiver. It's very unlikely that number one, they allow you to present the waiver, and number two, that they grant the waiver.
I'm going to say no waiver is going to be allowed.
In today's day and age?
To my point.
Yeah, I don't think so.
Maybe, well, I mean, what were the reasons?
90 as to
Did they
overstay of
overstay?
2.5 years.
Yeah, what was
Dude,
going on? Maybe
she
had
loves
some
the
medical
US.
procedure. I don't know. Maybe she had a health concern. I don't know.
Oh, I see what you're saying.
Right?
Like maybe there's a
a
legitimate
legitimate-
reason.
sure.
Maybe she's in rehab. Maybe she's like,
Oh.
you know,
Why'd
rehabilitating
you go
an
straight to
injury.
rehab?
It's like rehabilitating an injury. I mean,
Yeah,
like she had to have like, I'm not
car
talking about
accident?
drug or alcohol use. I'm
Car accident.
no. I'm talking like a car accident. The guy, you know, maybe I have pending litigation of a court proceeding that I'm, you know,
had to be here.
yeah, there's a lot of things there, Marissa. I'm going to say, yeah, it's tough. I'd rather you do the green card.
Yeah, you're more likely to get a positive response there. Vic PG1. Good afternoon. I filed VAWA after 12 months. USCIS is requesting RFE. Is it good or bad? It depends. Do you have the evidence necessary to respond to that RFE? I don't think it's neither good or bad that you received an RFE. RFEs come in all the time, even for VAWAs. You respond and it gets approved. I just hope you have the evidence you need as required. We take those on. Stephanie is great at them. So feel free to reach out.
I'm pretty good at VAWAs too. Okay.
I will tell you something. The fact that you got an RFE after 12 months is unheard of.
Isn't that pretty fast?
VAWAs are taking 48 months.
I know.
But do you think you're not answering the question? Is
You
it
think
good
good or
or bad?
What does the RFE say?
I
I
know.
think it's fine.
If it's a copy paste RFE, it's fine.
yeah.
Okay. If it's very specific because they're like, hey, we found out your husband sent a declaration indicating that you committed immigration fraud in the initial filing or something like that, like that's a different ball game, you know? Like we have to
Depends what the RFE says.
yeah. I'm of the opinion that fast is not good for that.
Send us the RFE
Yeah.
12
Yeah.
months.
and we
Yeah.
can assist in
The
responding.
bulk
Yeah.
of the bulk are
We've all
30
done it.
are 36 months, I think. The bulk of VAWAs, no? They're
48.
48. That's more to my point, you know?
I had a VAWA approved in 2 years, 24.
Lord,
Yeah,
wow.
in about
That
24.
is
But the
very
AOS
short.
is pending. forever.
Surprisingly short.
Yeah, Vic, contact us. We'll help you out. We all can do the VAWA for you.
Hold on. You already gave Vic to me. Don't take him back.
Hey, man, but someone had to teach you, right?
Listen, I'm going to tell you something. You've never taught Stephanie anything.
Maybe she won't
Okay.
say it on air, but she'll
There's
tell you
one
about the
person
VAWA
here that's
RFE.
taught her, and that's me.
Yeah.
Okay, it's not both
Actually,
of us.
You weren't here that night for the VAWA RFE. You were out on a boat living your best life.
Oye, él está jodedor hoy.
Oh my god.
That was a long time
we
ago.
learned together. It was the
I
one.
did one in
you know
law
what?
school,
This,
so
this
I
is
knew
a good.
I knew where to look
This
at.
is a good anecdota.
Yeah.
In the RFE, they called out. This is a good story. I'm sorry. In the RFE, they called out that in the wedding photos, they had like photo frames, and the photo frames had the stock
images. Yeah, you remember that?
I remember that.
That was
yeah.
such a crazy.
That was awesome.
I didn't need your help. I mostly was like, "What am I
How'd
going
you
to
guys
say
get over
here?
that? How'd you guys
We
overcome?
won.
How'd you overcome that
The
statement?
standard is on the floor for a VAWA.
Yeah, the standards on the floor.
It's
We ended up
basic.
winning, but
Very low
like,
standard.
are you saying that was a teaching moment, or that was just both of us trying to figure out how the hell we were going to respond?
Yeah, that's not a typical situation.
I think
They were,
we
like, in
won
the
because there
background of
was
your
there was a
thing.
lot of good evidence that.
How
was
about the
supportive
fact
of
that Alexis had that stock family photo frames in his office for years?
Years.
Years.
it.
That was probably part of my argument. I was like, I mean, if Alexis
If
could do it, this
normal-
girl could do
it's
it
a
too.
normal thing.
I bought the frame. I bought the photo, not the
uh,
frame.
What? All right. Are we done?
I know. Let's look. MF Constructor. I don't have questions. I'm here with an EB20W since 2024, but I always log in for all the lives to learn more and
That's
update
nice.
on news, Spanish, and English.
Thank you, MF
Thank
Constructor.
you so much. We very much appreciate it.
What do you think MF stands for? Like Mario Fernandez? Or what are
I
you
think
thinking?
I think it's the most fabulous constructor.
you
but
really,
I'm not
you
too
really
sure.
caught
I
me.
think it's
you
the
really
most
caught me on
fabulous
that one. I'm not gonna lie to you.
Sorry, MF, I'm joking. with
Listen, MF.
you. Okay.
Thanks for following.
Oh, here we go. Let's go to sure. Irving, EB1A petition filed June 27, 2025, Bolivia consulate with a son of derivative with F1 visa in the U.S. turns 22 this year. AOS. When does USCIS have answer for I-140 approval in CESPA opinion? 20. Oh, his name is Mario Fernandez.
The most fabulous.
How
You
did
know,
you guess
I'm gonna
that?
tell you
I'm so
something.
sorry I interrupted
I'm a
you. I just
weird.
really-
I'm a weirdo.
That was weird.
Mario. I'm a weirdo. Stuff like that happens to me all the time. Listen. I'm gonna say your kid might have aged out.
Well, final action.
Wait.
Final action. Dates are current, right? So technically, I think it's okay.
You think it's okay if he files the AOS
Yeah.
because it's been pending for over a year? It's been pending 13 months.
Sorry, the I-140
has not been
been
approved.
approved. I thought it said it was approved.
No, filed.
If it's approved and the visa bulletin
sorry, does
final
it need-
action
does-
remains current, then it'll be valid as of that date. And then we'll reduce the time that it's been pending.
Has been pending.
Which, so it's possible. It's still possible.
It's not impossible.
It's been pending for more than
But
a
if the
year.
idea is for it to be approved and then you enter the US to do an AOS, you're going to lose 3 months with that situation. if you're entering
Immediately
as a
file the
tourist.
DS-160, or, I mean, it doesn't matter, but sorry, DS-260 for consular. I think
Very difficult.
I think since EB-18 has mostly been current for quite some time now, final action date, right? There is hope. It's like one of the very few, maybe the only visa category that you ever have really on your side. So maybe. Let us know how it goes, Irving. We're dying to know.
Stay tuned for the Spanish show Thursdays at 12 noon.
Thank you, Angie. All right, Eladio.
Eladio.
Got the-
Bring in the love.
How'd you know it's crazy? How did you guess that?